Hello, my name is Phil Ferguson. I'm one of the shareholders at the firm Christensen and Jensen, where I do civil litigation. I primarily handle defense work, but I do a little bit of everything. And I've been practicing for 25 years, more or less. I'm going to discuss responding to discovery requests today. I hope that I can stay awake while I give you the speech, and I hope you can stay awake while you listen to it. Most of litigation is devoted to the process of discovery, either preparing requests, responding to requests, evaluating what you receive in response to your requests, and fighting motions to compel. I'm going to talk about answering discovery requests specifically. And I propose to do a fairly practical, step-by-step process. The first thing that you should do when you receive a set of discovery requests from opposing counsel is calendar the due date. You need to be particularly concerned about requests to admit, because failure to respond on time means the requests are deemed admitted. It's important to file or calendar a deadline for making objections, because recent case law indicates that untimely objections are the same as waived objections. And if you want to have a legitimate objection, it needs to be filed on time. You also need to make note of whether your discovery request was served by hand delivery or by mail, fax, or email. If you received your discovery request by a process other than hand delivery, you have an extra 3 days mailing time to respond. If you received it by hand delivery, you lose that 3-day period. You need to make sure that that is included in your calendaring. I think it's a good idea to call opposing counsel and request the electronic version of the discovery requests. If he or she will send them to you, it saves you the agony of having to retype them, and makes the process of responding quicker. The next thing you should do after calendaring your response due date is to review the requests themselves. Start with instructions and definitions that most lawyers include in their requests these days, and consider objecting to them if they enlarge your obligation that otherwise applies under Rule 26 of the Utah Rules of Procedure or of the Federal Rules of Procedure. Sometimes the instructions and definitions are boilerplate, you can ignore them. Once in a while, those instructions or definitions will actually narrow your discovery obligation, in which case pay attention to them, because it makes your job a little bit easier. I have found that if I dictate either my objections or the answers that I know right while I'm reviewing my discovery request for the first time, that it saves me a great deal of time, and then I don't have to go back and redo it. It also gets the project underway. I don't like the practice of making general objections. I think it's far more efficient and far more useful to object to each discovery request that you believe to be objectionable. And if it's not objectionable, then answer it. And don't worry about making the boilerplate general objections. I think you should ask yourself carefully, do I need to object? A lot of attorneys will object just for the sake of objecting, and I confess to having been guilty of that myself when I was young and stupider than I am today. I would avoid it. If you don't have to object, don't. I'd also encourage you to look at a recent case. In fact, all lawyers, and particularly young lawyers, should look at the case Aurora Credit Services, Inc. versus Liberty West Development, 2006 UT App 48. It was filed February the 16th, 2006, and discusses a number of the discovery problems that can come up in most civil cases. It addresses a lot of the cute tricks that opposing counsel think they are playing on the other side or on the court, and outlines some fairly severe penalties for playing those tricks. And in that case, the plaintiff had the lawsuit dismissed with prejudice for failing to respond to discovery requests in a timely and proper manner. And so these are important things. When reviewing the discovery requests, I suggest that you consider whether you need a protective order. Has opposing counsel asked for trade secrets, proprietary information, information that is protected by HIPAA or by GRAMA, the Government Records Management Access Act, or by other statutes that you need to be alert to, and the provisions of which you don't want to violate? Or are there other protective orders in other cases that govern the documents and information that you've been asked to provide here? You need to think through all of those issues early, and I think it makes sense to do it during your first reading of the discovery request. And if you think a protective order is going to be required, I suggest drafting one right away. Many firms will have a form protective order in a brief bank or in some kind of a network file, or your client may have a standard protective order that it likes to use. They're not that difficult to prepare, and you may as well have one in the works so that you can have it signed and in place about the time your discovery responses are due. I think that once you have reviewed the requests, dictated what objections you think should be dictated, and answered what questions you can answer, and then examined the need for a protective order, that you should bundle up your proposed response with the original request and get them to your client right away. Your letter to your client should emphasize the date by which the response is due, and should also indicate a date by which you will follow up with your client to make sure that the discovery requests are responded to on time. And you should put those dates on your calendar, and you should follow through with them. You may have to get your client on the phone. You may actually have to go visit with your client. Some sophisticated clients are a little better at responding. Some unsophisticated clients may need a little more intervention on your part to get their responses put together. I think it's a bad idea to allow your client to draft answers to interrogatories. I think you should prepare those interrogatory answers based upon the information that your client gives you. That way you can prevent inadvertent disclosure of confidential attorney-client or work product information. You also can then begin the process of putting together a privilege log if there are going to be confidential or objections based on confidential material. And I always recommend that when you receive the materials back from your client, that you, we used to say Bates number in the olden days, but put a document control number on the documents, which can be done electronically these days, through most digital printers, or you can do it the old-fashioned way with a Bates stamping machine. But number each document. That allows you to keep track of them. It makes the preparation of a privilege log a lot easier, so that you can identify the document number, the author, the recipient, the date of the document, and a very general statement about what the document is to put in that privilege log. You may need to help your client appreciate what types of documents they should be pulling together for you. Frequently, and at least in my line of work, that will be a liability policy or a health insurance policy, medical bills, medical records, all of the names of doctors and healthcare providers, tax returns, names, addresses, telephone numbers of witnesses, anything that tends to relate to the issue. If you have a sophisticated client, you'll probably be working through general counsel or through a risk manager or sometimes a human resources director. You need to make sure that they have touched base with all of the relevant departments of the corporate entity to make sure that all of the people who are involved in the case have provided their files and materials to one person, so that you have confidence that when you submit your response, you have provided a complete response. That often is harder to do with a corporate client than it is with an individual client. And occasionally you have to get pushy, maybe even ugly, with your own client in order to get the information. If you think that you are going to need an extension of time in which to respond, you should arrange for that before the deadline comes. It's not uncommon to need an extension, and most counsel are willing to give an extension. 9 times out of 10, you'll be needing an extension just as often as your opposing counsel will. You may as well work things out early and be gentlemen and ladies about the process. Extensions should be confirmed in writing, either through email or a letter, and in federal court, probably confirmed in the form of a stipulation and an order these days. Extensions are especially important for requests to admit, so that you don't have the problem with having them deemed admitted. Carefully review your proposed responses and answers. Make sure they are responsive. Make sure that you've protected against the disclosure of privileged information, and then send them to opposing counsel. Sometimes you'll find that you have the information all ready to go, but you don't have a verified response. I will often send the unverified response with a note saying that the verified response will be coming in the mail. And then when the verified response does arrive, I send that to the opposing counsel. If there have been changes made by your client in the process of verifying, then I think it's a good idea to bring those changes to opposing counsel's attention. Best of luck to you in responding to discovery requests, and hopefully this brief treatise will help you avoid many motions to compel to come.